and welcome again. Please, everyone, thank you very much for joining us. Welcome to our, well, am I live? Now I'm live, okay. Thank you, guys. So welcome to our live sessions on Facebook and on YouTube. You're listening to Lior Samfiru, and we are here to talk about employment law. I'm the employment lawyer. That's why I'm well suited, hopefully, to talk about workplace rights, to talk about employment law. We do this session every single week at this time on this day to help you understand your workplace rights. So this is live. I'm live right now. You're live right now. You're seeing me. So ask your questions. I am not just here because I like to talk about employment law, even though I do like to talk about employment law. I'm here because I want to answer as many of your questions as possible. So if you want to know something about your workplace rights, if you have a workplace problem, maybe you're off work now because of the many closures around the country, and you want to know how long you can be off, what your rights are, ask away. Now is the time. If you're on a layoff and you want to know how long you can be on a layoff, or if you're even allowed to be put on a layoff, ask now. If you've gotten some sort of an ultimatum from your boss, maybe your job has changed, your hours of work, your compensation, whatever the issue is, whether it's COVID-19 related or not, now is the time, now is the place to ask your questions. So don't be bashful. Take advantage of the fact that I'm here, you're here, and ask away. Now, let me give you some other information before we get started with our session today. You may have questions that you don't necessarily feel like posting right now. You may want to have a private chat with me by email, by phone, not a problem. To do that, all you have to do is go to employmentlawyer.ca. Again, employmentlawyer.ca. And when you go there, you'll see all the contact information, my phone number, my email address, all the information for myself and the rest of my team is right there. So if you want to have a private chat or you want to learn more about your workplace rights, go to employmentlawyer.ca and you can get all that there. It's a very comprehensive website, a lot of information, articles, calculators, tools, all kinds of things that allow you to assess and determine your legal rights, and of course my contact information. But that's for after. For right now, for the next 30 minutes, I'm here. I'm all yours. I'm all ears, and I'm here to talk about your workplace rights. So if you want to know something, questions, problems, issues about your workplace rights, post them. You have that box on your screen. You can type it in, press enter, and I'll see that question and I'll answer it right here, right now. So don't be bashful. As we're waiting for questions today, our first questions, let me start with talking about some of your employment law rights during COVID-19. COVID-19 has changed a lot of things and has impacted all of us in terms of the work that we do, our job security, our income. So I want to talk about some unique questions and unique situations that I've been getting, certainly over the last year, relating to employment law and COVID-19. But I'm doing that as in between your questions. So please, for now, in the meantime, ask your questions. Please ask them, and I'll be able to see them. So first question that I'm going to answer is with respect to, again, with respect to COVID-19 is, do you have to go to work physically, or can your employer make you come into work, or can you insist on being allowed to work from home? So, and for the most part, an employer is allowed to insist that you come into work from home. Come into work in the office. What I mean by that is that you don't necessarily have the right to insist on working from home. Now, in some situations, for example, in Ontario, we have a stay-at-home order that says that if you are able to do your job from home, your employer should allow you to do that job from home, okay? So in that case, you have to during the stay-at-home order. Beyond that, though, an employer is allowed to require you to come in so long as that employer takes the proper precautions that are dictated by the government in terms of wearing masks, in terms of physical distancing, in terms of limiting number of people within the workplace. As long as the employer is taking those measures, you are fine. All right. So let's not forget about that. Those are very, very important. So that answers that question. Remember that any questions, ask me. I'm going to start answering some questions right now from Cynthia. Are employment contracts that are signed when starting a job airtight and not enforceable should you get terminated without cause. So a termination without cause, Cynthia, is actually legal. An employer is allowed to terminate you without cause. If a contract is unenforceable, it could be for other reasons. For example, a termination clause in a contract may not be enforceable because of the way it was drafted. Probably 85–90% of the time, it's not enforceable. So an employer is allowed to terminate you for cause as long as they pay what they owe you. In most cases, in the vast majority of cases, when your employer is able to let you go, when an employer does let you go, they offer you a lot less than what you are actually legally owed. And that is the issue. So Cynthia, if you've been let go, let's talk about what you're owed. Let me know what you've been offered, and I'll tell you what you're actually owed. By the way, Dan Stone, if you're watching, I still am not able to scroll through the questions. Next question from Janine. My employer is forcing any staff who may have been exposed to COVID to stay at home unpaid. I have paid sick days. Can they not allow me to use them? So generally speaking, an employer is allowed to decide when and how to use sick days. Because an employer is not legally required to provide sick days, they can decide how to do that. So they can decide in this situation you can use sick days, and in this situation you cannot use sick days. So that's very, very important to remember. Now, that said, you do have certain government benefits that you'd be able to qualify for. So those would kick in those situations. But until the government requires employers to provide paid sick days in COVID-19 situations, an employer can choose how you do that. Hopefully, Janine, that explains it. Next question. Again, post your question, guys. I'm really happy we're getting a bunch of questions. I'm going to answer them all. Now's the time. Now's the place. Please post your question. Next question is from Simbat. There are lots of jobs now posted saying remote work available. Do the remote workers have to come back after COVID is over, once they were allowed to work from home? So let me paint this scenario. Let's say you always used to work in the office, and during COVID, the employer says, you know what, now because of COVID, you can work from home. Once COVID is over, the employer is allowed to tell you that you have to come back into the office. In other words, the employer is allowed to go back to the way things were pre-COVID. So you can't say, well, because I worked during COVID at home, now I have the right to stay at home forever. Not necessarily. Now, if you're being hired specifically to work from home, that's what you were hired for, then your employer cannot now say, now I've changed my mind. Now I want you in the office. But if you were hired to work in the office, were allowed to work from home, then the employer can say, now that things are better, you can come back into the office. So very important. Now, if your employer does change terms of employment, this is for Simbat and for everyone else, if your employer changes terms of employment, that can result in what we call constructive dismissal. So if you were hired, for example, to work from home, now the employer changed their mind and they say you have to come in, that could be a constructive dismissal, meaning you may have the right to treat that as a termination of your employment, okay? So if you want to know more, if you understand more about this, please don't hesitate. You can always reach out to me through employmentlawyer.ca, and I'll give that again, employmentlawyer.ca, to connect with me through Facebook, through the website, through phone, through email. By all means, reach out. But for now, again, we're live. I'm live. Hey, I'm waving at you live. Ask your question right now. I'm the employment lawyer, Lior Samfiru, so take advantage. Next question comes from Evelyn. She says, our company has had us sign a COVID temporary layoff as of March of last year. Does this mean I have to wait till July till the government pandemic is changed? I am still getting health benefits. No, you do not have to wait till July. Now, here's the thing. You think July would be the end of it. No, it could last another 8 months past July. 8 months after July. That takes you to February or March of 2022. But Evelyn, that's only if you decide to accept it. Regardless of what you may have signed back last year, you can choose to treat this as a termination now and get your severance now. Depending on how long you've worked there, you could be owed as much as 2 years' pay. But if that's what you've decided, Evelyn, if you say, I'm not going to stick around and see what happens over the next however many months, I want my severance now. If that's what you choose to do, before you do anything, I want you to call me or email me. I want you to go to employmentlawyer.ca. Let's connect. Let's have a private chat so I can find out more about you, about the company, about your job, what you did sign, and then I can, of course, assess what you're owed, and we can then decide how we go about getting you what you're owed. All right? So very important. You do not have to wait. Not you, Evelyn, not anyone else. You have a right to treat your temporary layoff as a termination. Now, if you choose to wait, you could be waiting. Again, we're talking Ontario in this particular situation. You could be waiting until March 2022. That's another 11 months. Okay, a long time. So thank you for that. Again, ask your questions. More questions are coming on right now. I'm going to answer them. Next question from Amy. Can you explain why salon owners and like business owners have to provide EI for chair renters and how they should receive a T4 for that? So Amy, salon owners don't provide EI. The government provides EI, right? Those are government benefits that government provides that. So I'm not sure I understand the question. I have to provide. So I don't know exactly. I guess what you mean is why the individuals are considered, why the people working in the salon could be considered employees. So let's be very clear. An employee is someone that essentially has a regular job. So if I'm a hairdresser and I go into the salon every day, I do my job. I don't necessarily bring in the clients. The salon schedules the clients. I go home in the evening, come back the next day, do the same thing. I'm an employee. Regardless of what the arrangement is, renting the chair, I'm an employee. And if I'm an employee, I have the rights of an employee, which means my employer, the salon owner, has to also pay, remit taxes, has to pay its share of EI and CPP. So but on the other hand, if I work in 5 different salons and I decide which salon to go to, then in that case, I'm an independent contractor because I don't have a regular job. But if I work just in your salon, regular hours, then I am an employee. And then as an employee, you have the obligations to me and I have the rights of an employee. Oftentimes, hairdressers are misclassified as independent contractors when they really are employees, okay? So hopefully, Amy, that explains the issue. It is very common with salons that the individuals, the hairdressers, are misclassified. Thank you for that question. Again, ask your question. And if you want to connect with me off Facebook, of course, employmentlawyer.ca. Next question comes to us from Anne. If an employee has a provision in their offer that in case of termination, you will receive the notice and payment as set out in the Employment Standards Act, can you still negotiate with the company? So, Anne, in 90% of the time, those termination terms are actually not enforceable. For technical reasons I don't even need to get into, they're not enforceable, meaning you're not actually limited, that your termination entitlements are not limited to the minimums in the Employment Standards Act. So yes, you're owed your full entitlements, but we need to review your job offer letter and assess it. That's not something you can do on your own. You need a lawyer that really knows what he or she is doing to be able to assess the enforceability of it. As I said, in 90% of cases, they're not enforceable, but we need to assess it properly. So if you did sign something that speaks to the issue of termination and you're concerned that it limits your entitlements, contact me. Send me a copy of it. I'll review it and I can tell you in 30 seconds whether or not, in fact, it does limit you. Okay? Do not assume and for anyone else, just because you signed and tries to limit your severance, your termination entitlements, just because it tries to do that doesn't mean it's actually doing it successfully, that it's able to do that. It may not, meaning you may have greater entitlements, significantly greater entitlements than what you believe you would otherwise have. All right. And by the way, for anyone else, if you want to know how much you're owed, your full entitlements, if you lost your job, best place to go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. We have a severance calculator tool there that allows you to determine how much severance you're owed, how much compensation you're owed, how much termination pay you're owed, what is it in fact that you're owed if you lost your job. Pocketemploymentlawyer.ca. It's free, it's anonymous, it's easy to use. You don't have to put in your name, the company's name, a credit card number, nothing. It's just there for your information. So check it out at pocketemploymentlawyer.ca. You'll be surprised by how much you're actually legally owed. Next question from Mark. Can employers in construction mandate that their employees use their vacation time instead of being paid for vacation time? So yes, any employers, in fact, not just in construction, can determine when employees use their vacation or mandate vacation. In fact, employers can schedule it. For example, an employer can say, Mark, I've scheduled your vacation for June 7th. So you're going to be off for a week, June 7th. Now, that's a kind of a crappy thing to do, right? Because you want to be able to control your vacation. But an employer is still allowed to do that, to schedule the vacation. And as long as obviously it's a paid vacation, then they're allowed to do that. So most employers allow employees to have some control over vacation, but legally an employer is allowed to say, I'm deciding when you're taking your vacation this year and using up your vacation that way. Okay. Hopefully that answers that question, Mark. William says, good job. Thank you, William. I appreciate it. Ask your questions, guys. You know, we still have plenty of time. Please ask your questions. If you're here, I know you have questions. I want you, when you turn off your browser, you turn off Facebook or YouTube, that you've had your questions answered, that you feel hopefully better about your situation. Next question from G Apple. If my employer is about to let me go and give me a severance deal, but I have another job lined up, if I get the new job offer, should I take the deal on the table? Well, I would need to see the deal on the table and what that is. And I also would want to know about your new job. Is it at the same pay? Is it the same terms? So you may have less leverage to negotiate if you have a job lined up, but I still have to see that offer. And depending on when you start the new job, we may be able to negotiate even before that new job starts. So the devil's in the details. Don't accept that severance offer. I don't care what it is. Do not accept it without having a chat with me first. That applies to G Apple. That applies to everyone here. Anytime you're looking at a severance offer, a severance letter, a termination letter, whatever you want to call it, do not sign on that dotted line ever without having it reviewed. And hey, listen, if you don't like me, fine. Speak to another employment lawyer. That's fine. That's how important it is that you have it reviewed. That I'm telling you, that's okay. If you don't like me, speak to someone else. But you have to get it reviewed, because if you don't, you will find out after the fact that you were owed another $30,000, $50,000, even $100,000 legally owed, and you signed off on much less than that. Don't let that happen to you. If you want my help, my team's help, I think we're the best at it. Easy for me to say, but that's absolutely what I believe. Contact me through employmentlawyer.ca. Again, employmentlawyer.ca. Great questions coming, guys. Wow, awesome questions today. So please keep them coming. Ask away. Next question from Julio. Can your employer discipline you for calling in sick due to COVID reasons? Well, if in fact you are sick, if you have a doctor's note confirming that you're sick, you absolutely cannot be disciplined. No, think about it. Discipline, the purpose of discipline is to correct behavior, that's unacceptable. What behavior is corrected if you're sick? Don't be sick again. That's ridiculous. That said, if you're not actually sick, you're just maybe concerned about COVID-19, I understand exactly why you'd be concerned. I'm concerned too. But if you're not actually sick, but you're just concerned, that is not a reason to take a sick day. You need to be sick, unable to work. And if your employer asks for a doctor's note, you need to be able to provide a doctor's note. If you have that doctor's note, Julio, you can be off as long as needed. And you cannot be disciplined in any way, shape, or form. Julio, if your employer tries to discipline you, if they give you warnings, put you on probation, whatever, because you're sick, no. Call me. Let's talk about that privately. You can get my contact information at employmentlawyer.ca. Okay, employmentlawyer.ca. Thank you for that, Julio. Great question. So Ann wants my email address. Ann, just go to employmentlawyer.ca. You'll see the email address there. It's just easier than me reading out that email address. Just go to employmentlawyer.ca. You'll see my bio there, my email address, my phone number. You see on the screen right now, employmentlawyer.ca. that's the place to go to if you want to get my email address. Comes directly to me. I can answer you, so please use that. Next question from Simbat Bay. Can an employer change and modify employee duties and responsibilities after employment started already without the employee's consent? So the answer generally is no. An employer cannot make significant changes to terms of employment. So they cannot reduce pay, they cannot change your hours, they cannot relocate you, they cannot demote you. Now, an employer does have the right to make some more minor changes. So for example, instead of 9 to 5, if your employer says you're going to be working 8:30 to 4:30, that's not going to make you happy, but that's not a significant enough of a change that it causes a legal issue. But if instead of 9 to 5, they say you're going to be working 12 to 8, no. That's a huge change. So if it's a significant change, Simbat, then what it does is it gives you the right to treat that as a constructive dismissal. Okay? A constructive dismissal is a situation that because of that change that the company made to terms of employment, you are treating it as a termination and you're requiring your employer to pay you severance. That's what a constructive dismissal is. So Simbat, if you're in that situation, if you want to know whether the change that your employer has implemented is significant enough to be a constructive dismissal, contact me. Call me or email me and let's have that chat. employmentlawyer.ca to get that information. So please don't be bashful and reach out. And keep in mind, if you continue working with the change, you're considered to have accepted it. So you have a very short window to do something about it. So don't sit on your rights, please. Great question. Guys, we have some more time here. Please ask. Don't hesitate. Take advantage. I'm here. So ask your questions just like everyone else's. You see how easy. I'm going to continue answering questions. If they're coming, I'm answering them. Next question is from Mark. Follow-up questions. Do employees have any time off throughout their first year of employment? So strictly speaking, vacation accrues in that first year to be taken in the second year. Most employers allow you to take time off, but they don't have to. An employer can simply, vacation accrues in that first year. So strictly speaking, it starts in year number 2. So if that's what your employer is insisting, again, most employers don't insist on that. But if that is what your employer is insisting, that they can do that, yes. Thank you very much for that, Mark. Next question from Michael. Will working at a new job part-time affect my severance pay settlement? It might, although if there's a big gap between what your income used to be and the new income, it may not. So I need to understand how big a gap it is. But generally speaking, it would not. There's, again, especially in Ontario, there's new court decisions that say when someone is just taking some sort of a very different job to earn some living in the meantime, it's not going to impact severance. All right. So, but again, as I said before, Michael, the devil's in the details. So I'd want to know more about the job. I'd want to know about the severance offer. So let's actually look at it specifically rather than talk about it hypothetically. So reach out to me and let's have that chat if you want to through employmentlawyer.ca. I'll continue answering questions. We got 7-8 minutes. Please, guys, ask your questions. From Facebook, Tammy has a question for us. How long does an employer hold your position if you're on sick leave? Great question. So in terms of sick leave, you actually can be off, okay, as long as you need to be, so long as you have a doctor, okay? Now, your job is only going to be strictly protected for a few weeks, but that doesn't mean that you're automatically let go if you're gone for more than a few weeks. So what I mean by that is you could be off for a year. I hope you're not need to be off for a year, but if you are off for a year, that still means when you're ready to come back to work, your employer has to make all reasonable efforts, to bring you back to the same job. Only if that's not possible, but they've tried, can they then terminate you with severance, with compensation. So don't assume that you lose your job just because, you need to be off for a long period of time. Get that doctor's note, focus on getting better, focus on healing. Once you're ready to come back to work, the company has to make all efforts. If you don't think the company is trying, they don't want to, they're not looking, they don't want to even bother, illegal. That's a human rights violation, potentially. You call me and let me deal with it in that situation, all right? So hopefully that answers that question, Tammy. Don't worry about that. if you're sick, be off work. Okay, you have to be. Great questions today, guys. I think these are some of the best questions I've ever gotten. You're some of the best people that I've ever watched my segment here. So that's awesome. Employmentlawyer.ca, of course, to connect with me off air. From G Apple, can I negotiate a reference as part of a severance deal? Absolutely. A standard thing that we negotiate is reference. Oftentimes, we also negotiate outplacement counseling, so that's someone to help you with your job search and resume and whatever you need to do to find a new job. But a reference is a standard thing. Now, if you're thinking though to try to negotiate severance on your own, please don't do that. Please don't ever try to do that. It's not going to work. You're not going to get anywhere close to what you're actually owed. But yes, when we negotiate severance, do we negotiate references? Absolutely. It's a standard item that we negotiate as part of every severance agreement. Okay? Please reach out if you want to have a chat about that. Brian says, can an employer require a new employee to get a COVID test? As long as that's part of the pre-employment arrangement, so as a term of employment, you agree to take a COVID test before your first day, they can do that. They can't do that after the fact if that wasn't agreed to before, unless the person otherwise has been exposed or there's a risk with that person. All right. So if there's no reason to be concerned about safety, about COVID-19, about exposure, no, the employer cannot require a COVID test. That said, here's what I'll say about that. I told you the legal answer. The answer is no. That said, you also always have to think, do you really want to get into a dispute with the employer over that? It may not be a comfortable environment if you get into that dispute. Despite the fact that an employer doesn't have a right to do it, I think given COVID-19 and how unique a situation, we may want to have more flexibility. And if the employer really feels more safe that we have a COVID test, we may provide that test just so that everything is fine. Can they insist? No. Should you actually do it? I say perhaps. Okay. So hopefully that answers that question, Brian. Questions are coming in. Look at that. That's great. Thank you, guys. Ask away. From Tammy. Been off 2.5 years with the mental health issues. They called and said my full-time job is gone and see what job is available. I work in healthcare. So Tammy, I'm assuming you're not part of a union. If you are part of a union, the only one you can talk to is the union. If you're not part of a union, don't worry about it right now. If you're still off, get better. Do what you need to get better. Maybe you can come back to work next week, next month, next year. I wouldn't worry about the job. Once you're ready to come back to work, only and then you tell the company, I'm ready to come back to work. If there's legitimately no job for you at that point, and there's no job that's acceptable, they can terminate you with severance, with full severance. But that assessment can only happen when you're ready to come back to work. Don't worry about it right now. Do not worry about it. You're still off anyway, right? So once you're ready to come back to work, maybe it's in 6 months, provide that doctor's note. I'm ready. I'm clear to come back to work. They have to try at that point to take you back to the same job. If they've tried and it doesn't avail, it's not available, it doesn't exist. If they can't find something similar, then they have to pay you your full severance. Don't worry about it now. Deal with it when you're ready to come back to work. Any issues, any problems, contact me. Okay, don't hesitate. From Julio, can your employer ignore your sick note and delay your pay intentionally? No. So first of all, if you have a sick note, they have to, well, it's not up to them to accept or not. It is what it is. They have to take it. And your employer can never avoid paying you, ever. That's illegal. You can file a complaint with the Ministry of Labor. You can contact me, and I can give them a bit of a nudge or a kick in the pants. But no, that would be illegal. Wow, I think we've had a whirlwind here. Let me give you a couple addresses once more to connect with me and my team, employmentlawyer.ca. Again, employmentlawyer.ca. You can see my email, my phone number, my team. We have a team of 35 lawyers. You can connect with us so that we can help you. All right, in Ontario, in BC, in Alberta, employmentlawyer.ca. Or you can go to also pocketemploymentlawyer.ca. It's like having an employment lawyer with you in your pocket on your smartphone at all times, okay? Pocketemploymentlawyer.ca, all right? So because of that, when you go to pocketemploymentlawyer.ca, you can calculate your severance. You can find out if you're an employee or if you're an independent contractor. You can find out if the company had cause to let you go. You can find out if your matter is considered harassment or discrimination. You can do all that and more for free, anonymously, pocketemploymentlawyer.ca. And there's also a button there that you can use to contact me. All right. So if that's what you want to do, pocketemploymentlawyer.ca, you'll see that on the screen right now. Check it out. It's your best friend when it comes to employment law. Thank you, guys. This was a great segment, great session. Thank you so much for listening, for all the great questions. I hope I've helped solve some problems and make you feel a bit better. I'll be back next week at the same time at the same place. But don't wait a week if you have questions. Reach out to me, employmentlawyer.ca, and we'll have that chat before then. Thank you very much. Enjoy the rest of your day. I will speak to you soon.